Okay, today we're going to talk about the First Amendment freedom of speech. Okay, so what we need to talk about it specifically is that, speech is one of the most important freedoms that the founders actually believed was necessary in this new democracy. And so the protection of freedom of speech, it was a big deal. And so we're going to look today at, the protection of freedom of speech, and we're going to focus on some Supreme Court decisions in terms of the Supreme Court's reflection of a commitment to individual liberty. But it's really important to point out that speech in the United States is not absolute. We do not have complete freedom of speech. There are restrictions that are put in place in terms of what we can say and where we can say it. With those restrictions, however, the government does set a very, very high bar when it comes to censoring American citizens. An important case to talk about, and this relates to what's referred to as symbolic speech, is a case from 1969 known as Tinker versus Des Moines. And this involves some high school students, and this was during the Vietnam War. These students planned to have a protest, but kind of a silent protest, meaning they were going to wear black armbands with peace symbols on them as a measure of protest in the Vietnam War. The interesting thing is they went into the principal's office the day before they were going to protest, and they told the principal of their intentions. And the principal said to them, if you wear those armbands tomorrow, it's going to create a huge disruption. So I forbid you from wearing the armbands. If you wear the armbands, you're going to find yourself in big trouble. Well, the students turned around the next day wearing the armbands around school, and they were called into the principal's office and were promptly suspended. And they were suspended for creating a disturbance, a disruption in the learning environment. That's what the principal had said. And so, the students argued that this sort of prohibition violated their free rights to free speech. And in fact, the principal had allowed other students to do certain forms of demonstration at school, and they didn't face any penalties at all. And so, anyway, during their suspension, these students were approached by the actually from their local civil liberties organization and told, hey, we can represent you. We feel that your suspension was, in fact, a violation of the First Amendment, your rights to freedom of speech. And so, of course, they kicked the cases up to the various appellate courts, appeals courts, and were rejected each time until they made it to the final U.S. Supreme Court. And at this point, the American Civil Liberties took up the case. And the U.S. Supreme Court, in fact, determined that their rights were indeed violated in terms of their ability to silently protest at school. And so the Supreme Court reasoned that they weren't creating a significant disruption in the classroom learning environment. And so, in fact, they ruled in favor of the students, and basically the students' rights to symbolic speech was upheld. But let's flash forward to the year 2007 in another symbolic speech case. And this was a situation where students were going to be taken to a local parade off of campus at a local school. And, the permission was given by the principal for these students to leave campus and to view a parade. The Olympic torch was going through town. And the teacher thought it'd be kind of a nice field trip for the students to see the Olympic torch. And so the students did go off campus and they were, at the parade. And two of those students decided it was a good idea to unfurl a banner. And that banner said, "Bong hits for Jesus." It was a joke, obviously, that the students had made. And so as the result of this, there was quite a bit of publicity. I believe that the local news media had picked up on this as well. And so as a result, these students were suspended from school. And this was also a case that went before the Supreme Court, determined, saying, well, this was our symbolic speech moment. And as a matter of fact, we were off campus. We weren't even on campus during this time. The Supreme Court took up the case, of course, and determined that the students were at fault, that they did not have a constitutional right to display a banner with a pro-drug message. In fact, the school had very established rules about anti-drugs on campus. The students couldn't wear T-shirts with drug paraphernalia on those T-shirts. So in other words, there was an established policy of anti-drugs on the campus, and these students broke that policy. The fact that they were off campus really didn't make a difference because they were involved in a school activity and they were essentially under the supervision of a teacher during this time. And so therefore their suspension was considered to be valid. And so the Supreme Court basically said, in order to maintain an appropriate learning environment, the school has the right to create rules that if broken, students can be penalized for. So now we see that, of course, it demonstrates that students do not have an absolute right to speech. I forgot to mention that under the Tinker versus Des Moines case, very famously, an associate judge, Aide Fortas, said that students and teachers don't shed their constitutional rights at the schoolhouse gate. That's certainly true. Even with this Morse versus Frederick decision, students do have constitutional rights inside the school, but of course the school has certain rules as well to maintain proper, quote unquote, proper order, et cetera. So it's kind of a balancing act. Here's another case. We're going back in time to 1943. This has to do with compulsory speech. Compulsory speech is where you're being told you have to participate. And in this particular case, we're talking about the Pledge of Allegiance. And this was at I believe it was at a local high school. And, every day the students would do the Pledge of Allegiance, maybe the first thing in the morning. It's still done today in high schools. And in this particular case, a student decided to opt out or determined to opt out of the Pledge of Allegiance because the student was Jehovah's Witness, practiced the faith of the Jehovah's Witness. And part of their belief structure is that you do not salute the flag. And so this student was, in fact, and just like in the other two cases, the student was suspended for not participating in the compulsory Pledge of Allegiance. And this did make it up to the Supreme Court. And the Supreme Court ruled in favor of the student, stating that compulsory speech violated the rights and beliefs of this particular student. And so, in other words, people cannot be compelled to do something if it is against, in other words, compelled to speech if their belief system determines that they are not to participate in such activity. And so again, compulsory symbolic acts cannot be compelled by the government, as it would suppress dissent in a free society. So that's the major outcome of this all. All right. Now, this is important to bring up. I mentioned it earlier, the idea of balance. So when the Supreme Court decides on issues related to freedom of speech, they have to attempt to balance individual freedom with social order. And so, what is freedom? On the one hand, the students at the school with Morris v. Frederick, the students felt they had freedom to demonstrate symbolic speech, but at the same time, there's a balance with order in terms of what the school rules are, whether or not student activity disrupts the school order. And so constantly, this is a balancing act with most of the Bill of Rights that the court has to weigh. So one way by which the court can put a little bit of control over a situation is through what's referred to as time, place, and manner regulations in terms of when speech can take place at what time and in the manner in which they're being delivered. For example, is it going to be through a parade or is it going to be at a park, et cetera, et cetera? So this is part of the Brandenburg rules that were established by the U.S. Supreme Court, and this is very important because it puts in a little bit of control in terms of the local authorities. For example, usually a permit is required during a parade or an event. It's necessary to get a permit, and that really allows for the ability for local law enforcement to be able to potentially be at that event in order to try to keep, maintain some sense of law and order. Imagine the Ku Klux Klan, for example, deciding that they're going to demonstrate and maybe even burn a cross in a space, that's permissible. So the time, place, and manner regulations are very important because then and there it's it kind of puts a somewhat of a level of control over the situation. So these types of regulations are referred to as content neutral, which means that this restriction of when, where, and how is important, but not the content. There's no control over what the actual words are being said. And so, the Ku Klux Klan could say the most vile things, and they're allowed to do so. And really, for some people, it's like, well, why would we allow this sort of thing? Why would this kind of hatred be allowable? Well, very famously, a Supreme Court justice said, I believe it was Felix Frankfurter, who said the remedy to offensive speech is more speech. In fact, that if people are uttering offensive speech, it's still other people's ability to counter that with more speech to counteract that. The Supreme Court and the American government sees speech as being absolutely essential in our democracy. There are three other categories of language, though, that are not necessarily protected under the First Amendment, and those categories are defamation, offensive speech, and obscene language. So defamation simply means that you say something in order to try to damage someone's reputation. And if you say something that is so potentially damaging that the person suffers, for example, they get fired for you accusing them of being a thief and it's not true, that is not protected speech. In fact, you could be sued by the individual who you've falsely accused of something. And then offensive speech is another category. And I'll just include something referred to as fighting words. If you start antagonizing a person to such an extent that you trigger them into a potential pushing match because that person is triggered in such a way, you could be held liable for your offensive speech using so-called fighting words, and that is not protected under the First Amendment. That doesn't give the other person the right to hit you, knock you onto the ground. That person would be held liable as well and probably suffer a more serious consequence of that. But again, you're not free when you trigger someone deliberately to put them into a fighting stance. And then, of course, there's obscene language. That's not necessarily protected under the First Amendment. We know that the standard for obscenity, though, is usually based on what the community sees as obscene. So one person's idea of what obscene is, and it may not be another person's definition. But we do know that for television viewing, for example, on public television, there's a prohibition on the use of extreme language, and the Federal Communications Commission can come in if during the so-called family hour, the show or program has a number of offensive language, obscene language as it is. And so, in fact, the network that shows this sort of show that has the obscene language can be fined for that. So again, it's not protected under the First Amendment. But the last point bears notice. It's like whatever constitutes offensive or obscene, that can be very challenging in terms of how do you determine what is offensive and what is obscene. We're all different. We all have different standards of what we regard. And so it is a very high bar that is difficult to get over in terms of punishment for the so-called obscene or offensive language. Here's another area of interest, and this has to do with something called the clear and present danger standard. This has to do with the famous case from 1919 called Schneck versus the United States. This had to do with World War I activity, where a gentleman who was an avowed socialist was positioning himself outside a recruitment station and handing out literature. And the literature basically said, do not go off to war, do not serve in the United States Army, you're going off to die for capitalistic purposes. I'm kind of summarizing the type of literature. And so this gentleman was arrested, and he was charged under the Espionage Act, a pretty serious charge. And so, of course, this went to the courts, and he argued that, what about my First Amendment rights to, in fact, express my views on the war and whether people should go to war or not? Well, this was a situation where the Supreme Court, in fact, backed up his charge and his arrest by saying, by you discouraging people to going for war, you're in fact presenting a clear and present danger to the United States because you're literally discouraging fighting forces that may, protect the United States during wartime. And so this was an interesting standard, and it was the idea as well. I believe it was Oliver Wendell Holmes who also said, if you discourage people from going to war, it's like shouting fire in a theater. Wrongly shouting fire in a theater, and people begin to fall all over each other and get injured or maybe even killed. You're responsible for that sort of speech. It's speech that will provoke and could harm others. And so again, this was a standard based on wartime, and the big picture is that this standard, to a certain extent, still is upheld. During wartime, it is possible that certain words and utterances are not protected under the First Amendment. And certainly, of course, obviously, giving out information that might compromise the security of the United States is a prime example of that. But again, the court has a pretty high bar in terms of determining what is so-called seditious speech versus, opposition to the war. Certainly during the Vietnam War, people were burning their draft cards, and veterans coming back from the Vietnam War were actively encouraging people not to go and fight in the Vietnam War, and they were not cited for that. So, with more modern times, it's very unlikely that you'd be arrested for expressing, saying don't go off to war, et cetera. But again, during wartime, when we're under attack, there are a lot of things that tend to happen that really challenge our understanding of what our freedom of speech really is. So finally, the protection of the freedom of speech in the First Amendment, it does reflect a commitment to individual liberty, but it is not absolute, as I've just gone over with you. And the Supreme Court's interpretation of the amendment will consider factors such as symbolic speech, time, place, and manner, and other considerations. And really, the bottom line is we seem to have quite a bit of the freedom of speech in this country, but it is, again, not absolute.